Hello, this is Matt on the Moon Lambo channel, and we have yet another legal bombshell in the SEC versus Ripple case. And you know what? Look, there have been a number of these within the last week or two, and so I'm going to resist the urge to write in the thumbnail or the video title the word bombshell, although I'd be absolutely correct to use it. I'm just a little concerned at this point. There's been so many huge revelations. I'm concerned that people are going to start to become numb to the term bombshell, but I would absolutely be right to use it here if I wanted to. But this is absolutely big, and it's not just me that thinks that. In fact, attorney Jeremy Hogan, who of course runs the very popular YouTube channel Legal Briefs, he also believes that this is absolutely a bombshell. I'm going to share with you some comments from him in this video. And so here's what's going on. Ripple has come up with a very clever way of approaching the SEC's arguments. One of them in particular, you'll see what I'm talking about in just a little bit. They're basically using the SEC's own words against them. And the biggest part of this, in my humble opinion, of this entire analysis for this video, is the fact that the SEC actually prepared a legal analysis of XRP before their investigation against Ripple started. And they don't want that to see the light of day. And so they're making some piss-poor arguments to try and hide it. And you'll see what I'm talking about here. Now, although that's the most important part, and I promise I'm not trying to tease everybody listening here, that's going to have to be towards the tail end of this video because I need to cover this sequentially so that everything makes sufficient legal sense. So unfortunately, if you want to get to the real meat of this, you're going to have to go through, and it won't do you any good to jump ahead either. You really just need to take it all in here. And I spent, honestly, the last, I don't know, probably hour and a half reading this. So I printed this head up. You hear that? Got some dead trees up in this bitch. So I printed this bad boy up, and I highlighted the parts that I found to be most relevant, and then I actually did make notes because there were things that came to mind that I wanted to make sure I didn't forget, which is not normally what I do with my videos. I prefer to have minimal planning. I always have an idea of what the types of things I want to say, but I've always found if I overplan something like that, then the content it's too rigid. So I try and stay away from that. But this is the time to make an exception for something like this. But yeah, for my videos, I prefer them to be just more organic, like the way that I'm talking now. It's the way that I'd be speaking with you if we were sitting down on a patio drinking a beer together, something like that. That's the way that I prefer to run the channel. And so this is going to be interesting. So please stick with me if you can. I'll make this video as I'll try to not belabor all the points. I'll try and make it as short as possible. But I have a feeling this one might go a little bit longer than I'd like it to. Maybe it's not going to be a monster video, but look, I never know for sure when I start recording these things how long they're going to go. It's just however long it needs to be. That's how long it's going to need to be. That's how long it will be then. But I do want to be clear also at the outset that I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos about asshats at the SEC, but purely for fun, purely as a hobby. That's all that's going on right here. And so a shout out to James K. Filing for sharing this legal document. And I am going to jump into a couple of Jeremy Hogan's tweets as we go through this year, but this is the actual legal document filed yesterday, September 28th. And so I'm going to jump on to page 2, and I'm going to jump in right about here. So here we go. And so here's what you need to know before I even start reading what they covered here. The SEC is pretending it's not legally required to prove Ripple, Brad, and Chris Larson were reckless in their actions. So that's why Ripple wrote what I'm about to share with you. But they absolutely are required. That's part of that's the burden the SEC has. They must prove that there was recklessness in the way that Ripple, Brad, and Chris behaved, or else they're not going to have a strong legal argument. And so here's what Ripple's attorneys wrote in this most recent legal filing. The SEC continues to obfuscate the standard for the recklessness element of its aiding and abetting charges. Defendants recognize that recklessness is one of two potentially sufficient mental states alongside actual knowledge, but the SEC has pled its case as one of recklessness. And to establish recklessness, the SEC must show the status of XRP as a security throughout the entire charged period, which is 2013 through 2020, and that it was so obvious that the individual defendants must have been aware of it. The actions and reactions of others, particularly the world's foremost securities regulator, bear directly on how obvious the regulatory status of XRP was or could have been to anyone. And so, yeah, and that's why this is why this all matters, though. These documents, because the SEC is trying to hide specific documents. This is what I talked about in probably the last. Well, I guess it was it just yesterday. These days blur together so much, like I can't recall exactly when I put out a video on a specific topic frequently, but I believe it was just the other day. I know that. But anyway, they write, in order to prove its allegations that the individual defendants aided and abetted Ripple in offering or selling unregistered securities, the SEC must show that the individual defendants knew or recklessly disregarded that Ripple's offerings and sales of XRP required registration as securities and that those transactions were improper. And so put simply, if the SEC observed that others were acting as the individual defendants acted, then there was at least ambiguity in the market regarding the status of XRP under the securities laws, or if it was unable itself to determine whether XRP or other similar digital assets were securities, defendants are entitled to discover that evidence and present it to the finder of fact. So, yeah, pause right there. This is exactly the reason that they're even having to say this, is because the SEC again is attempting to conceal what is highly relevant documentations, highly relevant evidence for this case. And you'll see that this will probably not be the only time I say that in this video. As we go through, you'll see more and more. This is the SEC's tactics. And so when we were talking months ago about what would be in these Bitcoin, Ether, XRP documents that the SEC, the court order, the SEC must share, would there be skeletons in the closet? I was hazarding a guess that the answer would be yes. To what degree? Didn't know, still don't know for sure, but it's becoming clearer. That's why you just wait until I get towards the later part of this video. The legal analysis of XRP that the SEC did? My gosh. There's a reason that Jeremy Hogan is saying, yeah, this is bombshell territory here. Anyway, and then they also write here, Ripple's attorney write, consistent with the court's prior findings, these materials are clearly relevant to Scienter, in addition to Ripple's fair notice defense and analysis under Howey. And so Scienter, this is this idea of the defendants, Ripple, Brad, and Chris, having to have known that what they were doing was wrong. That's that they did something wrong, but that they knew it and there was intent, right? And that's actually that's of legal importance here. And then check out this. Okay. Onto the next portion of this. Ripple points out the SEC fails to articulate why the documents in question are privileged. And so here's what they wrote. When the SEC finally turns to the actual purpose of the briefing, it fails to articulate any specific policy-making process implicated by the documents it is withholding, nor does it demonstrate how requiring their production would chill any such process going forward. Instead, the SEC relies on boilerplate assertions, offering little more than what it provided in its original privilege logs. And I love this. Listen to this. These assertions grow no more compelling by their repetition. I love that. You gotta love the way they wrote that. That is an appropriate jab. I love that. These assertions grow no more compelling by their repetition. Yeah, just keep saying enough and then it becomes true. All right. Well, thank you, you bunch of asshats. Then they're right. Documents are not privileged merely because they were created by the SEC staff in the course of their jobs. And then this next portion that I'm about to read, this is what Hogan was tweeted about, and I'm going to show you his tweet. Let me read this, and then I'm going to show you Jeremy Hogan's tweet. And this is absolutely astonishing. Like, this is it's such a brilliant legal text. So check this out. Because again, don't forget, the SEC is claiming that every single document, it's privileged and should not be discoverable in this case. It should not be evidence. Ripple shouldn't be able to use that to defend themselves. That's what the SEC is saying here. And so here's what Ripple's attorneys wrote. Rather, to sustain an assertion of DPP, and by the way, when you see DPP, that's what they're talking. That's privilege. That's what they're talking about. Rather, to sustain an assertion of DPP or privilege, the SEC must connect each and every document to an agency policy process and support its claim that they are deliberative in connection with that process. The difficulty for the SEC here is that it has never undertaken any policy-making process with respect to digital assets, and its entire case rests on its view that the application of existing law to digital assets was so clear that no such process was needed. The SEC's position is legally untenable, and accepting it here would be extraordinarily prejudicial to defendants. So, how do we sum that up? Well, just look right here. This is what Jeremy Hogan wrote, Attorney Jeremy Hogan. He wrote, "Clever," in all capital letters for a reason. Clever. Ripple argues that the deliberative process privilege, that's DPP, deliberative process privilege, does not apply to any of the SEC's documents it does not want Ripple to obtain, because the SEC itself has never deliberated about policy about digital assets. Think about that. They're claiming privilege over all of this, but they never deliberated, right? There can't be any privilege here, right? Right? It's just such a brilliant argument, because again, the SEC, and they say this, has never deliberated about policy having to do with digital assets. And then he writes at the bottom here, e.g., for example, Hinman was only deliberating for himself, not the SEC. So you can't have it both ways, right? It's privileged because it's something that's official to the SEC, or if it's not, then you can't claim privilege because, for example, with Hinman, it's just his personal opinion. A genius. That's why when he wrote clever, I was like, oh yes, that's clever. Clever Ripple. Which makes me think of that line from Jurassic Park. Clever girl. What part of the movie is that? Is that when the Velociraptor finds out how to open doors? I haven't seen that movie in forever. Great movie, though. Velociraptors opening doors. How silly. All right. Let me flip a few pages here. This is a big mofo document for real. I mean, I printed up bigger ones. Like this one's 21 pages that's without the exhibits or appendices, whatever. But some of these things are over 100 pages. So let me just make sure I don't pass over everything I wanted to cover. Just bear with me one sec here. This is my wasting time song. Skibbity-doo-bop. Hey, there we go. All right, I think I found it. Oh, actually, I almost skipped the part. There we go. Oh, yeah. This is where it gets extra delicious right here. Salivating. Check this out. Okay, so this is, if you want to, here, I'll just pull it up on the screen here. Got to go to page 13 for this. Oh yeah, this is the meaty portion right here. Let me scroll on down. Scroll. Here's my scroll song. Skibbity-doo-bop. All right, there we go. The SEC's June 13th, 2018 Xrp Memo. Oh, yes. I love this. Check this out, my friends. I can't believe this is real. I seriously, this is why I like when we say bombshell, like, yes, bombshell. Absolutely. This is a figurative bombshell. All right. So the SEC's June 13th, 2018 Xrp Memo. Perhaps the most explosive revelation of the SEC's privilege log is that the SEC's Division of Corporation Finance, a division that operates distinctly from the Division of Enforcement, wrote a memorandum containing a, quote, legal analysis of Xrp, end quote. Now, let me say this. Because they wrote here, SEC's privilege log, it's the SEC's Division of Corporation Finance that wrote this. That's William Hinman's division. That's the division that he was directing right there. He was the director for Division of Corporation Finance. That's what William Hinman did, which again is a separate division having nothing to do with the Division of Enforcement. And you would expect, wouldn't you, the Division of Enforcement to be the one doing a legal analysis of Xrp, yet it was the Division of Corporation Finance, William Hinman's division, that did the legal analysis of Xrp. Well, how about that? So why would this division do a legal analysis of Xrp? No, seriously, tell me. Like, why? That was not rhetorical. Like, give me the damn answer. Like, why is the Division of Corporation Finance doing a legal analysis of Xrp? What the hell business do they have doing that? And obviously, because again, this is we're talking June 13th, And as I'm going to read the next line, but like this is the day before the William Hinman speech where Ethereum got its free pass. This is the day before that. You see how absurd and ridiculous this is? It's insane. So anyway, they write the following. In reference to the legal analysis of Xrp, they write, that memorandum was then circulated to certain individuals at the SEC on the day before former Director of Corporation Finance, Bill Hinman, good old Billy Hinman, gave a speech publicly declaring Ether not to be a security. The SEC's privilege log asserts that this document is attorney work product and subject to the DPP. So that's the privilege. And it asserts for the first time in this letter that it also is subject to attorney-client privilege. The SEC is incorrect as to all three privilege claims. And this is where the Ripple attorneys just shred them. Check this out. This document is not work product. First, if this document were part of the SEC's investigative file, as the SEC now seems to assert, it presumably would have been covered by the SEC's categorical privilege log, and no further logging would have been necessary. The very logging of this document suggests that it was not part of the investigative file and raises questions about what it is and why it was prepared. Yeah, so again, this is... Think about the privilege log that they claimed. It wasn't part of it because it wasn't part of the... Do you see what they're saying, right? I'm trying to make sure this is clear. Sometimes the way that the stuff's worded here can be complex. But actually frequently, very frequently. Especially for somebody like most of us. Most of us don't have legal backgrounds, so like going through this stuff, it can be a bit of a chore. Which is why it's nice when we have like John Deaton and Jeremy Hogan to break some of this, like the really legal stuff down, especially with their long careers as attorneys here. But anyways, so as far as the privilege wasn't initially claimed on these, but why wouldn't it have been? Why? It wasn't part of the investigation, right? What other reason would there be? And so again, if it's not part of the investigation, then how that's another reason it wouldn't be privileged, right? And so then they also write here, second, the SEC does not tell us who authored the document and when. All we know is that it predates June 13th, 2013, or I'm sorry, 2018, I don't know why I said that, and that it was sent by the Office of the Chief Counsel of the Division of Corporate Finance. And third, the SEC does not assert that the memorandum was drafted at the direction of enforcement counsel in view of litigation. Only that it was sent to a single enforcement counsel along with 9 other people who are not in the Division of Enforcement. All right, so why would it be, think about this, why would it be sent to 9 other people not in the Division of Enforcement if it's part of the investigation? Does that make a bunch of sense? Look at this. See, look at the thing. Look at the stuff that the asshats at the SEC with this legal team. Look at what they're claiming. It's bogus claim. Like the stuff that's coming out of their stupid little mouths, they know it's not true. Which is why I keep saying like these are not nice, ethical people. They're just arguing whatever the hell they want to argue, and they're just seeing what sticks. That's what they've been doing for 9 months now. But it's so bad. Like that's why I keep saying, like, fine, I'm biased. I've been in XRP for almost 4 years, whatever. But I'm telling you, like, an unbiased person just looking at the facts will find what we all know to be true. Like these are. This is, if the SEC gets their way, this is not justice. Like that I don't see how the judge could possibly fall for it at this point. We'll talk more about that in a little bit. But let me go a little bit further here. There is every reason to believe that the Division of Corporation Finance was looking at XRP's status under the securities laws independently of considering whether the Division of Enforcement might recommend an action to the Commission. Further, documents produced by the SEC show that yet another division, the Division of Investment Management, was assessing facts in relation to Bitcoin, Ether, and XRP around this same time. And fourth, the Enforcement Division did not open a formal investigation into Ripple until March 2019, months after this corporation finance memorandum was circulated, and did not file this action until a year and a half after that. And finally, although the SEC asserts that enforcement staff worked closely with corporation finance staff in connection with the Ripple investigation. Reliance by the Enforcement Division on expertise from corporation finance would not transform all of the latter's documents into pre-litigation attorney work product if they were not prepared for that purpose. And so here's the translation for that. The Xrp Legal Analysis, that memo, the Xrp Legal Analysis that the corporation, what's it called? The William Hinneman's division, the Division of Corporate Finance. There you go. So the Xrp Legal Analysis cannot be privileged because it's not part of the SEC's investigation into Ripple and Xrp. It predates the investigation. It can't be. It simply cannot be. And then next, check this out. Indeed, the SEC's own internal notes reflect that little more than a month after this memorandum was circulated in June 2018, Ripple CEO Brad Garlinghouse and others met with the chairman of the SEC, Jay Clayton, and director of corporation finance, Mr. Hinman, and that following those discussions, the SEC's own note-taker recounted that Chairman Clayton encouraged the Ripple executives to continue its ongoing discussions with the staff of the Division of Corporation Finance. How about that? With no mention of any ongoing enforcement matter. So they're talking to people within this Division of Corporation Finance, and then, unbeknownst to the Ripple executives, Brad Garlinghouse and everybody else that's at Ripple, this division did a legal analysis of Xrp, and it occurred before Ripple and Xrp were under investigation. And they continue here. The SEC's assertions of DPP and attorney-client privilege over this document suffer from the same overarching flaws described above. As to attorney-client privilege, a claim that the SEC makes for the first time in its brief, the SEC fails to identify who the client is, who the attorney is, and whether any information reflected in this memorandum was confidential and intended to be kept confidential with respect to the agency itself. Not every document prepared in the course of a lawyer's job responsibilities is protected by attorney-client privilege. With respect to the DPP, the SEC again fails to establish that this document was part of a policy process or was intended to assist the agency decision makers in arriving at a decision. In fact, the SEC did not present any recommendation to the Commission suggesting the opposite is true. Thus, the SEC's attempts to claim all three privileges over this document fail. Can't wait to see what the judge has to say about this. And then, let me scroll on down to page 16 here. Here we go. This is a good time here. Drafts of the Hinman speech. The Ethereum Free Pass speech, which took place again, June 14th, 2018. Entry 9 is a representative example of entries of the SEC's privilege logs for the drafts of Mr. Hinman's June 14th, 2018 speech. Opposing defendants' prior efforts to obtain related discovery, the SEC submitted a sworn declaration from Mr. Hinman asserting that the speech reflected his personal views, not agency guidance. The SEC cannot now argue that drafts of the speech are pre-decisional on the grounds that the speech itself expressed guidance from the SEC submitted to the market after internal deliberations, and thus the SEC is left to argue that the decision being deliberated was the content of the speech itself. So look, to be clear about this, what they're saying here, drafts of Hinman's speech can't be official SEC pre-decisional deliberations because they're just Hinman's personal opinions, which also means the SEC can't claim privilege over them. Think about this. It's obvious, but it's still a brilliant argument, even in its simplicity here. And so, look, this is just a blatant attempt to conceal highly relevant evidence in this case. And I think it's a bad attempt. I can't imagine. I can't imagine the judge just taking this in as an unbiased party and thinking, oh yeah, the SEC's got a good point. No, she's gonna think that Ripple's got a damn good point here. That would be my expectation here. And then they write, in other words, the SEC argues that the speech itself did not announce an agency decision about its policy, but that the decision over what Mr. Hinman would say, which the SEC and Mr. Hinman both characterize as his personal views, was part of the SEC's policy-making function. This circle cannot be squared. The SEC asks the court to accept its absurd claim that the SEC was engaged in a deliberative process over what Mr. Hinman should say in a personal speech, even though it is argued in this litigation that Mr. Hinman's speech did not provide any meaningful guidance to the marketplace. Damn, you gotta love this stuff. You've absolutely, which is, again, it goes back to what Jeremy Hogan was saying here in this tweet. Hinman was only deliberating for himself, not the SEC. You know? It's incredible stuff here. That might have been everything I highlighted for this. Or it's towards the tail end of the document. Yeah, that's the most relevant stuff there. Yeah, okay. So now that we've gone through the meatiest parts of all of that, and you can see just how completely absurd it is and why it is a bombshell, take a look at this. This is a tweet from Jeremy Hogan. So the part with it gets into the legal analysis of Xrp, that was on page 13. And so Jeremy Hogan just simply tweeted out, also, take a look at page 13 of Ripple's brief. Now, smiley face. Enjoy. Yeah, no kidding. There's a reason that he wrote that. And then XR Pizza for Dinner on Twitter wrote, Jeremy, what about page 13? Is that not a bombshell, or am I overreacting? And then Jeremy Hogan, you can see it's on your screen, he wrote, oh yeah. And the reason I said oh instead of oh is because there's 4 O's the way he wrote it here. Oh yeah, like the Kool-Aid Man. Oh yeah. Oh no. And then he writes, but let's leave that to others to mull over. Well, and then the smiley face. I'm another. I mulled over it. So you guys know what I think now. Then XRP Daddy on Twitter wrote to Jeremy, is there any chance of Ripple losing at this point? I don't see how they can lose, do you? And Jeremy wrote, there is always a chance of losing, especially when the majority of the case will be decided by one person. But the cards are really falling in place for Ripple at the moment. Yes. Which makes sense to me. Like, honestly, it's my unprofessional opinion because I don't have a legal background, but just as a layperson, seeing all of the evidence, like, the extent that we're aware of it, out there now, I don't see how this goes well for the SEC. In a world where justice is served, I don't see how the SEC comes out on top here. It's a tremendous overreach, and they don't poke the bear, so they don't have a bad time. And then there was this from Anders L. asked Jeremy the following. Serious question. Is the judge more patient with the SEC simply because it's the SEC? And that's such a legit question. You've heard me talk about this, right? Because I'm just sitting here like, how, like, it's sometimes I just wonder, does the judge at any point reading the SEC's piss poor arguments like get offended because like they're trying to trick her, or maybe they think she's stupid? Because that's how and in reading through this, I'm like, do they think I'm stupid? Because I don't have a legal background, but I'm sure as hell not stupid. Like I can see through this facade. It's a bunch of nonsense here. And so, again, he asked here, is the judge more patient with the SEC simply because it's the SEC? And Jeremy responded with the following. I don't know if there is some leniency here towards the SEC, as I've never been in this court before. I can tell you that some old cranky judges down here would have been knocking some heads together on some of these discovery issues for sure. Smiley face. Yeah, and so I do feel like, the judge has been nothing but professional and all that jazz, but I don't see a bunch of what do you even want to call it? Like I don't see the judge whipping down the SEC attorneys, and not that I necessarily had some huge expectation of that, but you've got to be wondering how she's interpreting all of this nonsense, because you know how I'm interpreting it, I know how you're interpreting it, because we're sane individuals and we're not liars. But the SEC, those are a bunch of asshat liars. That's the problem here. They're not being honest. They're just it's really this, like, do you even lawyer, bro? Like this can't be good lawyering, right? It can't be. It can't. Let me know what you guys think below. I'm gonna go ahead and wrap up here, but this is one hell of a legal document here. So I'm gonna go ahead and throw that on the ground and hopefully never read it ever again. No, I mean, I'm glad. I enjoyed going through it, and I was kind of getting fired up, just like marking up and taking notes and all that stuff. But damn, it's a lot to go through. You know what I mean? So anyway, I'll go ahead and wrap up there, though. I am not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.